Welcome to Fire Service Court. My name is Brad Pinsky, and I'm going to be your host today. And along with me, I have the Honorable Chip Comstock and the way more honorable John Murphy. And today we are the three lawyers of fire engineering, and we come to you giving brilliant legal advice, or we just make it up. Sometimes we never really know. So today we have a bunch of great issues, but first I think John has an announcement.
I do have an announcement. So this studio is brought to you by the Firehouse Subs and the Firehouse Subs Public Safety Foundation. Enjoy more subs, save more lives. Find out more about restaurant ownership at www.firehousesubfranchising.com.
Now, having just spoken about food, we should probably go on to marijuana topics, but let's skip that for the moment. We'll get back to that. So I wanted to talk about one of the hottest issues today in the fire service, in EMS service, and that is not just the use of ketamine, but the use of restraints. They're getting the EMS and firefighters getting involved in police issues. So one of the things, John, we're going to start with you. One of the things that we're seeing a lot of is ketamine chemical restraints overdoses, where we just have the EMTs, firefighters get dispatched. The police are trying to sedate or subdue somebody, and along comes Mr. Paramedic, right, and thinks, I'm going to be a hero, and I'm going to administer ketamine. And so, John, jumping to you, we've seen real of this, correct?
Yeah, there's several cases around the country. The most notable one is the Elijah McClain case in Aurora, Colorado, which happened a couple years ago, where the sort of the typical scenario is a young black man walking through a neighborhood, somebody reports in, the police show up. He's developmentally challenged, and so he's resisting their commands. And so they basically subdue him with, physical force, with a chokehold. Paramedics arrive. He's still struggling because he can't breathe. And so the order from the police to the paramedic is, well, administer ketamine, and we need to subdue this guy. At the end of the day, after 2 days in the hospital, the poor guy expires. And so there's a big trial. A grand jury convened initially, and then it went to trial. So the two paramedics that administered the ketamine got criminally charged. They'll be serving some time. And I think two of the police officers were criminally charged, and one was exonerated. So the issue that we had, and I just had this conversation last week with the Colorado fire chiefs, was that, what are the paramedics' responsibilities when they get into scenarios in interacting with police officers that, in essentially, they already have the subject subdued. And so the question is the person in custody, which is a police issue, or is the person your patient? And so if the person is your patient, then you need to take certain steps in order to provide proper patient care. Most of the patient care is found in protocol, right? And so following the protocol, yes, there is an administration of ketamine in the protocol, but no, there is no protocol available for how you interact with these sort of what I classify as chaotic police scenarios where they're subduing a patient, or now not a patient per se, but a subject, and then becomes your patient. So when I was researching, have we changed our protocols on how we deal with these sort of chaotic police interventions? There's nothing new out there. They're the same old nothing. I mean, I looked at the Colorado, or actually the Denver Metro EMS guidelines, and there's really nothing mentioned in those guidelines. And Aurora, Colorado uses the Denver Metro EMS protocol as a guideline. And the latest one was in 2022, and they haven't changed it at all.
So I think in Elijah, they gave 3 to 5 times the dosage because they believed his weight was greater. At least that's what they said. They believed it was a much greater weight, and they gave him, and he wasn't, right? And they gave him like 3 or 4 times the legal dose that he was supposed to give. So that was obviously results in the death. But we are seeing, there's another case I want to speak about, which was at a sporting event, and after the Roe v. Wade incident, there was a woman protesting, and they're screaming about Roe v. Wade at this big sporting event, and the police take her down, and the paramedic comes over and subdues her and takes ketamine and knocks her out. There was absolutely no medical issue that required it. She wasn't having a panic attack. Wasn't having a mental health crisis. There was no reason to do it. And what confuses me is Now we have EMTs and firefighters who want to be cops. It's supposed to be the reverse. The cops want to be firefighters. So I don't know what's happening. But the lawsuits are focusing on not just assault. We've seen assault, battery, murder, criminally negligent homicide. Right? We've seen those charges on the criminal side. But on the civil side, and Chip is our constitutional expert. Let's talk about what constitutional claims are made against these departments.
Well, the interesting thing, I mean, the first one that pops in my mind is that Section 1983 civil rights, which is under, again, the constitutional right to be free of illegal seizures, searches, whatever. But that you're basically ordered excessive force, right? Because you're applying a force to me, even though it knocks you out. If you end up dying or suffering medical injuries as a result of it, it's through an application. I mean, the argument is much more excessive than death. I don't know if you've seen any other constitutional issues other than that. But
no, the Fourth Amendment's been the big one, brought to you by 1983 claims, and there's been an attempt to say, take away my life liberty by removing my freedom of choice for medicine.
Well, you also have an Eighth Amendment.
Undue punishment?
Yes, right, because you're in custody at that time. And so that it's usually that only comes up in cases where you're under medical protective custody or in incarcerated. We don't see that now. They've tried to make Eighth Amendment cases before against medics, but they've never been in custody. Well, now in these cases they are.
Yeah, and I can tell you, these cases are popping up everywhere, becoming extremely, extremely frequent because for some reason EMS and firefighters are trying to get involved with the police. And I got to tell you, since the George Floyd left, this the public obviously, understandably, very upset, very on edge about this. And when we start pushing the limits, you're going to jail.
Well, at the end of the day, it's real simple. Do what's right from a medical perspective, right? We're not there to be police officers, or whether we're trying to be nice and helping officers, or they're demanding that we do it. The question is it medically necessary? In most cases, it's not, and that's how people get in trouble.
Yeah, and John, if you're competent and you have the capacity, right, talk about the ability of someone to refuse this care that you're forcing on them.
Well, that's an interesting point, because if I'm in a chokehold by a cop, there's no way I'm going to be articulating I'm resisting, I'm not resisting, I can't breathe, and that's what we've been seeing. Before we get off on that topic, there's another case in Illinois where they had two paramedics were forcing the gentleman that was in a halfway house face down on a gurney, and a lot of it has the evidentiary component of it was all the cops had body cameras, right? So it recorded every second of this thing, all the conversations. So it was like a frequent flyer comes in, the paramedics are, it's in 2:00 in the morning. They're all angry, I guess, to be in there. So they ended up throwing the guy down, face down, restraining him, and he dies from compression asphyxia. So one of the questions that is brought up is, why didn't anybody intervene, right? So it was a patient in distress, and so the cops are not going to intervene in the police side. The paramedics aren't going to intervene on the cop side. And so we've had people say, well, I don't want to intervene because I wasn't sure what's going on. And my position on it is a hogwash, because EMS has been around for over 20 years. We all know what everybody does, right? So we understand medication, we understand drugs, we understand protocols, regardless of whether you're a police officer, an EMT, or a paramedic. And so we need to take our steps to protect, these sort of clients, patients, victims, I think better than we have in the past. The other thing is, I think we need to have more training on chaos, right? So we're trained.
Chief has arrived on scene.
Yeah, Chief has arrived on scene. Yes, I love that one. So we're, as a paramedic or an EMT, we're always training in the clinical setting. We're controlled out in the field ride-along program. Well, how many times as a student have you intervened or gone on a call where there's all hell breaking loose, and you're asked to do something? And I think we could say never, right? And so the never component is now for the situation that we've never faced before, and we're asked to do something we probably shouldn't even be doing because we're going to harm the patient.
And that's really the issue. Stay within protocol, right? The advice is so easy. Stay within your darn protocol. That's it.
Again, and that should be medically necessary, right? Because you're following the policies.
So let's do this. Let's go for the drugs we don't want to the drugs we do want. Let's talk about marijuana. It's a great issue in the fire service.
Have a sub.
Yeah, so I'm sure Firehouse, Ron Stubbs is remote. Right? So marijuana in the fire service has become a really big issue. And, some of us have seen these issues because it's, people are arriving on something wrong or they smell horribly like, burnt marijuana. And the states are protecting people where the federal government isn't. And which is great. If there were only one court you could be sued in, but you could be sued for discrimination, right, in state court or federal court. So, Chip, based on what we've all been talking about, what is your recommendation for a fire chief who says, geez, this person shows up, he reeks, he or she's a little slow, we think they may be impaired, and let's assume we're in a legal marijuana state. What do we do?
Videotape them.
Yeah, explain that.
Well, the problem with marijuana, unlike alcohol, is we can do an alcohol test and know that that person is under the influence. With marijuana, they may have consumed marijuana 89 days ago. They're not under the influence, but they could test positive, and that's the problem we have. So, by videotaping them, we're going to see, are there signs that they're under the influence? Now, what are we testing for? How do we, want to use in the alcohol sense, field sobriety test, right? But in the fire service, we want to be more specific. So I'll turn that back to you.
And I kind of feel like since we're talking about marijuana, Elon Musk, I wonder if we're going to pull out a big joint right here and smoke while we're doing this. But so the I've come up with, because there is no great way to test for marijuana, right? We can't do a field sobriety test, which I think has a 82% positive predictive, success. So what I said is, okay, we don't want to falsely accuse somebody of being impaired by marijuana. And especially if it's medical marijuana, they're going to make a claim that I need it and you're violating the ADA. So we want to find a different way to say, okay, you can't do your job. So if you have job performance requirements, which says, paramedics have to be able to make dose calculations and firefighters have to be able to tie knots and force a door, all these complicated things, then test them on that. So now Chip comes in impaired pretty much every day. So Chip comes in impaired, and I look at him and I say, Chip, you seem high. And he's like staring at me. I'm like, Chip, you know what? I'm a little concerned that you may not be able to perform the essential job functions. I don't say I think you're high. And I say, here's a knot, a figure 8 on a bend. Can you tie that? And if he starts eating it or licking it or something, maybe.
We are making the assumption that the person knows how to do that anyways. I mean, that's one of the things. If a guy's crappy tying knots all the time, that may not be his best thing.
It's an essential job performance that we're, requirement we're putting in, but I don't care. It could be let's force the door. Or how about get dressed in your turnout gear, right, in a minute, 10 seconds or whatever the standard is. If that person can't do that, then I don't care at that moment whether they're actually impaired or not. What I can say to you is, listen, you cannot perform the job performance requirements. If one of them is you got to tie a knot or you got to get dressed or dose calculation, whatever, and you can't do it, then I can remove you because the moment.
And then are you going to test afterwards? Or are you going to do a test once they fail the job performance?
Yeah, and that gets us back to ultimately there's no way yet there's no epithelial test, there's no test yet to determine if somebody is impaired by marijuana. So I have a hard time doing anything other than removing them from the duties once and say, maybe the policy would say, and please have policies on this, is okay, if you are found 2 times, 3 times in a year unable to perform the job performance requirements, you're going to be terminated. Right. That's the only way I can come up with the deal with marijuana.
Well, I think the deal is that you need to have a reasonable suspicion policy, because we talk about policies. You need to have objective standards in there that you're attesting to. Right? So you just can't make the stuff up going on and all of a sudden we're taking Chip off the job because you can't fit my picture of what impairment looks like. So these things need to be done quite early before you're faced with the situation. And it's a reasonable suspicion policy. So you have certain standards or tests, and even you can take them to the lab and have them tested to see what's going on currently. But the question still comes in is, are they impaired? So if you had somebody that's been drinking all night, you're at a conference somewhere like Indianapolis,
hypothetically,
and you have to go to work the next day, and you're like reeking of alcohol, and you're in your bunk room sleeping, you're impaired. So what's the department to do? So they do the reasonable suspicion. Have 2 people witness it, put them into BC's car, take them over to your lab, and you can test them and you can determine the amount of alcohol or the type of drugs that are in the blood system right away. Marijuana, 30 to 60 days, but you can get, it's hard, right? It's very difficult to make those testing judgments.
Well, the other thing is even if we have all these issues, and Brad and I we may disagree, or John, with whether you should permit it or not, because you get into federal requirements on AFG grants and some other things. But there is a distinction on the state level between how states interpret the ADA, American Disabilities Act, as it relates to a medical card use marijuana, right? If you're in as Brad often refers to the Socialist Republic of New York, you're probably safe because they're going to view that that marijuana use is protected if there's a medical condition, that you have some protection under federal law. Other states aren't that way, and particularly in southern and Midwest states, there's a lot less protection.
Yeah, and we have definitely seen the federal courts, because look, under the ADA, which is federal law, if you are sued in federal court, then the ADA is going to say, I'm sorry, it's a controlled one substance, it's not legal, and you can be terminated if we can prove you're impaired. Now, if you admit you use it, like because I have PTSD or another condition, I admit I take 1 milligram of it, 2 milligrams, which probably 1 milligram is not going to really affect you much. I wouldn't use it on the job, but it shouldn't really affect you much. But hey, it's in your system. You admit it, you're done. Under the states are going to protect you. So in a real example, in the city of Buffalo, a very busy, active fire department, they had a PTSD individual. They, I think, terminated him for using marijuana, medically prescribed or recommended, and they settled the case. And I'm sure they would have. And we saw, like, very quickly he sues and they settle it. They return him to work, back pay, etc. If you're in a protected state, you're going to lose that. So we need to find, and that was really where I was going with my suggestion, we need to find another way to get them out of the job. And that's, to me, can they do the job or not? Let's stop it. Well, where do you want to go? You want to go to ADA? You want to go to OSHA?
OSHA's the new fear.
Okay, yeah, this is the hottest topic out there. The hottest topic out there.
Nobody understands OSHA in the first place.
Yeah, well,
now they're going to compound OSHA
to
rewrite.
So, as everybody knows, and I want everyone to take a breath, to go back to the last one, what you breathe in is up to you, but I want everyone to take a breath with the new Department of Labor regulations. And I bet if I scream to the people walking the hallway, how many people are panicking about the Department of Labor regs that are proposed? 26 out of 52 of them are going to say yes. 50 of them are going to say yes. 26 states are OSHA regulated or compliant states. So the new regs, listen, they have been for about 10 years. I've been following this for a very long time. And finally, they came out for public comment. The public comments ask really sincere questions. They want to know things that, what do volunteer departments do? What type of physicals do you get? What do you typically test at a physical? How many structure fires do you go to a year? People are definitely, the Department of Labor wants to know. There's no way these are coming out. And if I'm wrong, you cannot play this video back. But there's no way these regs are going to be implemented in 24. And my bet is we're going to mid 25. That said, what you have to do now is start preparing. And my number one suggestion, which will take us to the ADA, which takes us to everything, you have to now start implementing job performance requirements. Let me say it again. Right now, to prepare for the Department of Labor new regs, you have to start implementing job performance requirements. What does that mean? That means, and this is not about just interiors anymore. The fire brigade standard, this is replacing, was just about interior firefighters. Now, the Department of Labor is going to regulate every single responder on scene. So, one, you have to create a JPR, job performance requirement, for your interiors, your exteriors, your operators, your chiefs, your EMS, your fire police, whatever you got, everyone needs a JPR. And what do they look like? They look like, okay, interior firefighter must be able to wear 60 pounds of gear and crawl for 30 minutes wearing 60 pounds of gear. They also must be able to climb a 24-foot ladder wearing 60 pounds of gear and carrying 15 pounds of equipment. So you need, and I have about 30 JPRs. NFPA 1582 gives a couple of suggestions. It's a great starting point, but I have about 30 of them. Must be able to speak clearly. So you can call a Mayday, right? There's a lot of things that you need in your JPRs, and we're not ready. Once you have the JPR, now you can deal with marijuana,
And the JPRs go hand in hand with that job description. What is it that the person does, and then what are the physical requirements that go hand in hand? I mean,
Yeah, and please do not copy your neighbor's JPRs. For example, right? I give this example. If I draft, my department drafts, yours is all hydrants. Well, you probably don't have to stand up on a tanker, reach your hands above your head, pull out the hard suction going like this, right? Bend over and hold it, and then do that awkward thing where two people hold the cup between their legs and marry them up, which looks totally inappropriate. But nonetheless, that describes the job of at least drafting in my department. And in my department, you better be able to do those physical movements. So the skills and the physical abilities to do that will now help you, once you have that, prepare for medical examinations, and we'll get to ADAs, and will help prepare you for, can you do the job at all?
Right.
So that's where we need to start. That takes you some time. If you want help preparing, we can definitely help prepare those, but you need a JPR, very extensive, right? And don't just copy with NFPA 1582. It's a good start, but there's a lot more. Then once you've done that, now we can deal with the second and third biggest parts of the new DOL regs. The two things people are going to have trouble the most with: training and testing on the essential skills, and medical examinations. Those are two huge focuses of the new DOL regs. So let's kind of go to ADA, right? Let's go to ADA. So let me ask you a question, John. Should somebody who has no arms and no legs be an interior firefighter?
Probably not, but I would look at my JPRs.
There you go. The answer to all these questions is not what is your opinion, is what is the JPR? So,
well, and the other part of that goes is we have this great JPR, but then who's going to make the decision, right? Because am I qualified to do it? And, well, no, it's a physician, right? We're all going to turn to our physicians. Everybody does medical exams, but what do they know, right? When to your point, oh, he's an interior firefighter, he's an exterior firefighter. They don't understand physicians, unless you're one of the physicians connected with FDIC. They just don't understand a lot of times. So we have to work hand in hand with the JPRs, right?
Which means we have to stop an extremely common practice. And listen to us here. If you are sending your people to a doctor without JPRs, and I'll bet 98% of you are, at least, I'll bet most departments just say, let the doctor decide. Who the heck is the doctor to decide, right? A doctor now, okay, so John happens to be a PA, right, and does this stuff, but even he can't tell you what your JPR should be, and thus he can't tell you in your department what a physical should consist of and whether you're qualified.
Now, I'll tell you, the interesting thing in Ohio is that there's a prosecutor in the department wanted OHIO wanted to know what the doctor needed to make this determination. And the state attorney general, right? State attorney general says it's up to every doctor's discretion. Okay. It's up to the doctor makes a decision. Here we have standards, they have to do an annual certified medical exam. But the issue is, oh, that's great. Who cares? Doctor decides we're good to go, except for when we get the ADA claim. Right. It's great on the front end. We send everybody to a doctor, whether they have the standards or not. Right. You're qualified or you're not qualified. Good to go. But then when we get those claims against the department down the road, that's when we really get in trouble. It's not up front. It's down the road.
Yeah. The ADA. Let's talk about the ADA, right? Because a court's going to look at what were the JPRs and could you do them? What were your JPRs? Not what did the doctor think the JPR should be?
Well, I think the issue, they've come a long way, I think, on firefighter qualifications under the JPR. Because I've been doing this, practicing medicine for about 50 years, doing a lot of physicals. And so departments would send their candidates in to do a physical, right? And so they wouldn't send anything in with what the physical consisted of. So at my clinic, we have a physical form, right? It's like, you have two eyes, you have to check. Can you see out of those two eyes? Yes. You have two ears? Yes. Can you hear out of at least one of those ears? So it goes through this laundry list of what goes on a physical examination. But the reality is there's no EKG, there's no X-ray, there's no, prostate exam. There's the limiting blood tests to try to get the baselines for like heavy metals and cholesterol and all the things that, will eventually kill us. And so we've slowly come coming about. So recently, in the last 2 years, we've got a lot of wildland firefighters coming in or structural firefighters coming in, and they're bringing in a little bit more complete physical examination, history, physical, and my opinion of whether they're qualified as a firefighter, regardless of whether there's. And I've never seen a JPR yet. And so my pushback to the department is, well, you can't qualify until you do this test, and this test, which is in the NFPA 1500 standards. And I can't qualify them because we don't get a complete picture of the candidate when they're coming in for a medical physical. So that creates a conundrum for the department. Now, one of the things that they don't want to do is getting a chest X-ray and an EKG is a cost. Right? So they're trying to minimize costing, to try to get the cheapest way they can get their firefighters in, which is totally wrong. So and the other part is most physicians don't have a clue what we do because they've never done it. And so all they're doing is looking at a candidate, they look at a hunk of paper, and they try to make a determination of whether they're qualified. And that's when the ADA part comes in. So if they're not qualified,
they're going to sue you.
Yeah.
Right? They're going to sue you. And the courts look at two very simple things. Do you have a standard? And do the standards reasonably relate to the job? If the answer to either of those two questions is no, you lose. And if you have no standards and your only answer is, well, I send them to Dr. Chip to make a determination, you lose. Right? And I can give you case after case. You have no standards. So how can the doctor decide? It's a non-delegable duty.
And again, the section NFPA standard 1582, which is the medical exam, is a really good starting place, right? And one of the things that we see on that, I'm getting a little bit off topic, by you trying to have that not being tailor made, is people then take that standard and don't apply it properly. John, we go back with the incumbent versus the new hire. I mean, they make distinctions, and people say, well, we got a standard, we're going to use it. They don't even, when they use that standard, don't apply it properly.
Yeah. So I think the case in point that Chip's trying to make is that, so in the NFPA 1582 standard, there's the candidate standard and the incumbent standard. The candidate standard is pretty exclusionary. You have to be pretty good health in order to get in. There's category A and there's category B. Category A's are automatically discounted.
Like type 1 diabetes. If you have type 1 diabetes,
Right.
It's category A, you are not getting hired.
Right. Or heart surgery. So if you had a stent put in, you got a pacemaker, those sorts of things, they're not letting you in. Category B, however, is somewhat permissive, right? So you may be able to do additional testing to get more clarification on somebody who may have a cardiac arrhythmia, as an example, and they're determined to be okay to work, right? The candidate standard is a whole entirely different standard. Where we have a problem interpreting the NFPA 1582 standard is when it comes into incumbents. And so you have Chip goes off on a disability because he had heart problems. He gets a stent put in. He comes back to work. Fire chief goes, well, he can't come back to work. He has a stent put in. And in the NFPA 1500 standards, it says you're excluded because you have cardiac surgery. Well, you're reading the wrong standard, right? So if you're reading the incumbent standard, which is permissive. So if you get permission from your cardiologist, you're good to go, right? But they fight it like crazy because they don't understand how to read it. And the doctors won't help either. So,
and I'll tell you what, I take the category A again. If you have it, you can't join, right? Category B is if you have it, you can join, but only with a physician's letter. I take all of those, the category A's and B's, and I make them all B's on return to duty physicals, on annual physicals, right? If you got a condition, look, if you're on blood thinners, you get a crush injury, you're going to bleed out and die. I mean, that's how it is. But if your doctor says you can do it, so be it. I guess you can.
And a lot of times, we talk about referring to doctors and working with them and ADA claims. So just trying to hit another topic, I thought that sounds a lot like maternity and childbirth.
Oh, great one. So look, pregnancy. I always say, what do you do with somebody who's pregnant? What do you do with somebody who's pregnant? Do you tell them they can't do the job? You say, I'm going to look out for your unborn baby. What do we do with people who are pregnant?
And we see a lot of well-meaning chiefs who do just that. I'm taking you off the line because I'm trying to protect you or your child.
And you're right. They do seem well-meaning, right? The problem is, very softball answer, John. Whose right is it to say when I'm going to take myself or be put out of duty?
Well, the crowd would say this: the doctor and the patient, right? The fire chief has nothing to do with it, but fire chiefs tried to intervene to be the nice person, the nice guy or the nice gal, and it's totally illegal. And so the issue is, again, disclosure that you're pregnant. That's one issue. Second issue is you need to send at least the JPR to her physician, and say, this is what her job responsibilities are. Can she do the essential elements of the job? And if the doc says, in consultation with her, say, yes, I can do the job, then that's fine. So she comes back to work for a period of time until she can't do the job, or the decision between her and her doctor says, I don't think you should proceed in this profession because now you're becoming hypertensive. Now you're becoming overweight because you're retaining fluids. You're creating a hazard not only to yourself or your crew. And that's a decision, again, between the firefighter and the doctor, and not you as the fire chief. So you're on a slippery slope when you're trying to do the right thing, and you're going to get a discrimination claim because now I'm pregnant and you're discriminating against me because you're sending me off from work. And sometimes I don't have enough medical leave to go off of work, so I'm off the job and without pay. You're creating another undue hardship for me and my family.
And today, during our trip session, which we all participated with, thank you, we had a great question, right? So the first question where I started, and then somebody followed up, we'll go to Chip on this. The first question I started is, what do you do about their turnout gear? What if they can't fit in their turnout gear? Do you have to order a new turnout gear? And the answer is, look, if you have it, you got to provide it as they get bigger.
Well, in part of this is protecting, and it's a protecting, but also harming the fetus, because as we point out, one of the things you have to do with both the doctor, I think the responsibility of the chief is, as when you're dealing with the doctor and the firefighter, make sure they have enough education to make an informed decision. What's your job duties, as John said, and one of them is that what happens to you as a firefighter with respect to your body, and that's the idea.
Yeah, so the women in fire, I think they were women at the time. Kudos to them. Somebody did a study, and she actually happened to be in my class last year as I'm talking about this. And she said, people don't understand. What the study has found is that women who are pregnant, the harm to the fetus is that you put on turnout gear. We're exacerbating, we're energizing our body. We're getting very hot. The turnout gear gives out moisture, but does not give off heat. So we have a significant amount of heat we're retaining, and it actually causes significant damage to the brain of the fetus. So it's the heat. It's not, you're going in carcinogenic places. It's not, it's dangerous. I mean, clearly hypertension, all that are issues. But what they're saying is it's the heat. So it's not just while fighting fires. It's drills and training.
So there's those studies out there, and again, we want to educate the physician, saying this is what your patient or employee, volunteer is going to be doing, and here's the risk. You now have to work with your patient, who ultimately, as long as that firefighter is competent, has the right to decide what they're going to do or not going to do.
And the great question we got today was completely novel, is we have a hard toe standard, right? They're buying, I won't mention the brand, but they're buying these boots that everyone apparently is now buying, $300 boots. And it's a hard toe, and for the workstation boots, they're very comfortable, etc. And what happens when the woman is swelling and doesn't fit into them? Do you have to purchase a new pair of boots, or can they wear whatever the heck they want?
Tennis shoes.
Tennis shoes. And the answer we gave was what?
Well, you got to make the accommodation, right? So a reasonable accommodation. So you may have to buy the shoe, but not that shoe. You can buy the $100 shoe that has a safety toe in it, and not the $300 that has a safety toe.
And this became, and what we tried to say, and this is the tough part for fire chiefs or administrators, is the word is always reasonable accommodation, and what's reasonable. And the issue was, do you have to buy a $300 or $100 pair of shoes? We don't have to lower our standards, right?
Never violate your standards.
You don't have to violate the standards. You don't have to lower the standards. But if it means buying another shoe is $300 reasonable. Well, we had a person in the class whose fire department budget's $5,000. $300 may be a huge hit for that department. For somebody else who's multi-million-dollar budget, the jury who ultimately decides these issues may say that's reasonable as buying a $300.
Right. So you buy a $300 pair of boots as opposed to $1 million lawsuit. You can buy 300 pairs of boots. So it's a toss up. So
the problem
you
is
need to make the right decision.
But it's a slippery slope. You did that for this person, you did that for that person. Right. Our simple advice is don't violate your standard. And if you can't afford something to accommodate, well, then it's not reasonable.
Right.
So I really thought that was a great issue today. What else? What other?
Well, let me add one thing to that, because some departments will provide a quartermaster system, right? Yes. So they buy the equipment, right? Other departments give you an allowance, so you can go out and buy any shoe that you so choose under this particular allowance. So is it the brand A for $300, or is it brand B for $100, and I can pocket the $200?
Well, it doesn't meet that standard, and that's for that very reason. People tend to, hit shortcuts. Anybody who gives uniform allowance, I hate that. Fire departments have responsibility providing, uniform
Right.
gear and sticking to
That's my
standards.
point.
Next.
Okay, well, we've been hearing a lot. One of the hot topics now, because look, the United States Supreme Court, in addressing the law last year, addressing the law out of the Socialist Republic of New York on guns, and we have a lot of people now who are able to get concealed carries. And so the question, and look, it's not just a volunteer issue, but we have an issue where people carry, and can they then take them to the firehouse? Do they have to lock them up? Can they take them to a scene? Can they take them into an IDLH environment, which is filled with fire and heat? And people want to know, well, what I think is mostly happening. Should we just ignore it, not talk about it, and see what the heck happens? So we've given some suggestions. I'll start with mine, I guess. My suggestion is don't ignore it. Face the problem. And I have at least one simple rule. If you want to allow firefighters to bring them to work or bring them into the station, so at least the volunteers aren't saying, well, I want to carry, so I'm not going to respond to the call, right? If I honestly, very pro Second Amendment. And if you tell me it's a choice between never carrying or not coming to the call, I guess I'll join another fire department. But it's a volunteer issue. So my simple thing is, at a minimum, if you want to allow them to bring in the station, but you force them to stow it and lock it, provide lockers, not like these gear grid lockers and other lockers that have little safes and you can lock it up, but put a camera above it so you can see if anyone tampers with it. And that, at a minimum, is some of the things I'm seeing.
From a practical standpoint, like on a career department, I think there's a lot of issues with people carrying guns, and I have clients, departments. I mean, half the firefighters are carrying sidearms. The problem is there's a number of problems with that. One is you can't go in a post office or any other federal building.
Can't go to school,
right? Can't go to school. So that's problem number one. Then what do you do if you are carrying? Are you going to lock them in the rigs or the ambulances? Do you have spots there to put them? And how well trained are your personnel? Police officers have to qualify on a regular basis. They're trained, and they're used to continuum of force. They can use takedown methods, joint lock flows. They have tasers, they have mace, they have all sorts of things. And then, as a last resort, they have guns. If we're going to have our personnel carry guns, then that's the only choice we give them. So if I'm going to have my personnel carry guns, I'm sure it's not going to give them a taser and mace as well. The other problem is when police are on a scene, they're very watching the scene. It's situational awareness. We get on a scene, we're providing EMS care to the patient. We're not protecting our gun, and we don't know what else is going on. So that's a real risk. So I have an issue for all those reasons why I don't want my folks to carry guns on calls. And I understand there are departments that, because of a lot of other reasons, that they want to do that. You have to think through that policy. But at the I think the compromise at least is, okay, they're going to bring them if they're going to bring them to work, you're going to have to lock them up in their car and maintain them there. And Brad said from a practical standpoint, it doesn't get locked up in the car. It gets thrown under a seat. It gets left on the seat because people in a hurry. And Brad's solution is come bring them inside the station where we can make sure they're properly protected. But I think at the end of the day, it's like everything else we discuss. Talk about it in advance before it becomes a problem. Have a department policy with it that this is how we're going to address this issue. Don't, as you said at the beginning, don't ignore it.
And unfortunately, I'm sitting here with like two totally, liberal Democrats. I have no idea which in the fire service is unheard of.
We have guns. We have a lot of guns.
So, listen, you can't be on all sides of different things. We want to allow legalized marijuana. We want to allow you to carry guns. Both together, probably not good ideas.
Not a good idea.
But that said, now we've got about 5 minutes left. And one of the other things I'm seeing a lot of, as we read all these cases every week and talk about them, is privacy invasions in the firehouse. We're seeing a lot of privacy invasions, locker searches, desk searches, email searches. What do we need to do?
Okay. It's okay to do that. As long as you have one thing.
What is that?
A JPR? A policy.
We're going to be like policy guys, right?
No, it's the deal is people have an expectation of privacy in their homes and in their cars and in their workplace, in terms of their desks and everything else. on the department computer. You go use department computer. I have an expectation of privacy on that, and the courts are going to protect that unless
you have a policy that says you have no expectation of privacy using our lockers, our desks, our emails, our Wi-Fi, right? You've got to be so, it's a very simple policy to draft. But if you don't have it, you cannot be searching people's lockers. And the real case I actually had in my practice was somebody came in, they put a long gun in their locker. People were a little terrified of having somebody have a long gun in the locker. I think it was an AR. And, they were boasting about it. We're going shooting after. And then the department comes in with the police, unlocks it. The department says, these are our lockers to the cops, right? And the cops unlock it or break the lock, take the gun, take him out in handcuffs. And the whole thing gets thrown out because why?
The expectation of privacy, especially if you got a lock on it, right? If you got a lock, I mean, the reason I'm trying to do is exclude other people. So,
right, and I think people, they expect a privacy issue, even though we say there's no expectation of privacy. Some people say, well, if I put a lock on there, then it's my property. Well, it's not you're putting your lock on my property, and it's still my property. So get your lock off of there, and if you don't want to take your lock off, I'll cut it off because it's in my policy.
Right. That's exactly it. And, this is a neat transition to a totally different subject. What people think their rights are, right? For some reason, firefighters have this weird constitutional belief that anything I can do, I have the right to do. So let's talk about photography on scenes, Chip.
Well, I'm going to go there. We're going to go there, but I'm going to say my shortened version again. Social media postings. If you think you have an absolute right to post whatever crap you want on social media, you're wrong. You're going to get fired. It's career suicide. So if you really think you have a constitutional right, be our guest, test it out, and we'll be wrong. Here you go.
Yeah, that sums it up. And we have people who, and I'll throw it to John, we have people who, they go to the scene, right? They're inside someone's house. They're not doing anything. I got my cell phone in my turnout gear. Oh, look, a dead body that's been mangled. Click, click, put it up on social media. Real story, right?
Yeah.
Do they have that right? It's their own. It's their own social media accounts, not the department's account.
Well, you said it's not legal. It's never been really legal, but I think New York State and 5 other states have made it criminal to take those photographs and to distribute them, right? Yep. And so there is a large award, which I'm going to let Brad talk about, but there's a large award because people took unauthorized photos of a accident scene.
Kobe Bryant. We're talking about Kobe Bryant, almost $40 million for the sheriff and firefighters.
Huge award, right? People lost their jobs. $28 million or $40 million is a lot of money for the county to lose. And so, and you could lose that amount of money, depending on how sensational the case was. And I think, like Chip said, it's career suicide to put this stuff out on your social media.
Who owns the photograph? Right? Taking it on duty. You don't own it. That's not your photograph. And we can get into all the public record stuff. We're running out of time. But I mean, at the end of the day, again, back to policies. If you're a fire chief or administrator, have a digital imagery policy that's going to talk about who can take photographs with what camera, right?
Right. Hopefully a department issued camera, never your own camera. Do not use your own camera. Come on. What's a high quality digital camera? $100? I mean, come on.
iPad.
Or an iPad, which we have on the ambulances. And so look, I'm all for dash cams. I don't love helmet cams, but but no matter what cameras you allow, it belongs to the department. And we've had an interesting theme. We'll wrap up kind of on this. We've had an interesting theme, which is people's rights. All of these are people's rights to be high, people's rights to carry a gun, people's rights to take pictures or say whatever stupid crap they want online, right? People's rights to be free from search and seizure. And yet, then we go out and can't violate our rights, but then we go out where we started, we violate other people's rights by administering ketamine or subduing them or whatever it is. And I don't know what this entitlement is. It's not just firefighters, right? But what's this entitlement?
It's what people have to understand is that the Bill of Rights and the Constitution, none of the rights are absolute. We put restrictions on those rights all the time. You can go out and protest, but the government can say, this is the area which you can protest. We're going to define the area. You can carry a gun except in an airport or a courthouse. So we put restrictions on rights, and firefighters have to understand they don't have an absolute right to do whatever they want to the public, and they don't have an absolute right to do whatever they think they can in the fire station.
So with the last 15 seconds, let me say a couple of things. One, hi, Mom, our biggest fan. We've got to say hi to my mother.
Hi.
Two,
Hi,
if you
Mrs.
need help
Pesky.
developing policies, this is what we do. We have a great national service we can help you do it with. Find us online. Find me at my website. Find us through Fire Engineering. Thank you on behalf of John, Chip, and our long lost friend Kurt Frone, and myself, Brad Pinsky. Thank you very much.